Okay. Uh, um, Welcome to week number 8 of Introduction to Criminal Law. And all you guys are probably celebrating Thanksgiving or getting ready to celebrate Thanksgiving. So I'm going to go right into the lecture and I'm going to provide you with some information and details to help you. So let's start by sharing my screen here. Okay. Okay. Okay, so let's take a look at the module. Okay, so now we're on the module, and just to scroll down and remind you about all that stuff that's on there, make sure that you utilize that. Especially now you're coming to week 8. Week 8 now, from this quarter on, the rest point 8, 9, 10, and 11, you will have two assignments. You had a little break. So you're going to have written assignments as well as your project. So you're going to be making sure that you satisfy the criteria. Again, there it is right there for the written assignment to maximize your grade. And then coming down here to week 8, you have here your course project. And on defenses, make sure you 2 to 3 pages in length. Identify the various defenses that are applicable, explain the defense of self-defense and justify use of force, stand by your ground, and then make sure you satisfy the APA requirements. And again, to repeat, the APA requirements involve your citations in the body and references at the end. So it's very important. And this is where you can maximize 100 points. So you want to, excuse me, you want to make sure that over the next 4 weeks, 8, 9, 10, and of course 11, that you do well on both of these assignments. But notice this is the chance for you to get 400 points for your projects. You know, to go with that, you get 80. So a total of 480 points maximum for the next 4 weeks. So make sure that you take a look at it. It's right there in front of you there, okay? All righty. So now let's go over here and look at the announcement. And I'm going to refresh it here so we can see more. Defenses. This is one of my favorite lectures. And it's only one chapter. And defenses are very important to me. Well, why? Because I was a defense attorney for a whole bunch of years, criminal defense attorney. And so I did other things, as I've said before, but this was my passion and my heart. So I'm going to enjoy this lecture and then complete the activities, defenses to crimes. And be sure to complete your discussion assignment, which is due tonight. Stand your ground, and my rules on the rubric concerning the initial post and reply posts and how they need to look, and the things I like because I've shared with you in my comments throughout the quarter to encourage you. I've enjoyed most of the discussion posts of many of you, and where you needed to step up a little more, I've let you know that also. Finally, your written assignment this week consists of insanity, which is one assignment. That's the one for 20 points that I just showed you. And then the course project defenses. That's the one I just went over a minute ago with the 100 points. So you want to make sure that you do that. And then, of course, as usual, the quiz. Given some instructions about how you should best do your quiz. And I've stated time and time again, try to do your quiz at the end, um, and it's 10 minutes. I had someone ask, could you get more minutes? Uh, some time ago, I used to give 15, but then the school told me, says, no, you can't do that. I know what you're trying to do to help, but so now not to change the length of time. So it's clearly 1 minute per question. So you want to make sure you do that. And so we want to finish strong. And I've already shared with you my motto about adversity is the springboard to success. Okay. So now let's go take a look at the course calendar here. We go course tools. Okay, there we go. Course calendar. And as soon as it populates, here it comes. This is where we are now. This is the week. It tells you, what things are due. Tells you what your reading for this week is. I went over your reply post, your initial post. And again, if you click on it, it tells you what the topic is. Okay, so then it tells you about your written assignments. And again, as I gave you the rubric, I also provide to you a reminder. And then make sure you run your papers through Grammarly. Most of you have been doing pretty good with that. It is very, very important that you include your critical thinking. I am more interested in your critical thinking. And I provided you some information about critical thinking on the home page to help you out. So if you still had some concerns about that. Okay, and then of course the course project, same thing. 2 to 3 pages. Both of these assignments are. Make sure you have a cover sheet as well. You will lose points for that. Your rubric tells you how many points you will lose for not complying with APA as well. All right, so with that being said and done, let's dive into the module itself. Scrolling down here. Okay. So again, the defenses to crimes. So let's again quickly just go over the assignments. And these are the facts that you're going to use, 2 to 3 pages, addressing the following issues. Make sure you cover every one of them. There's 1, 2, 3 issues. And again, I already told you about the requirements for APA. You don't see it right here, but you're already aware of that. Also, you should be aware of that. I put in a little warning early in the quarter from even the open house to remind you that all written assignments, I just said all, don't ask me, even if it doesn't say APA in here, that you have to satisfy the APA requirements. Because if you look at this, you don't see it, but if you look at the rubric, and if you also look at the course calendar on the assignment, you'll see that. So you can't miss it. Can't miss it. So on insanity, and then your discussion post. Same thing with your project. Discuss the various defenses that are applicable to the party. Be sure to discuss defenses of self-defense, justifiable use of force, and how stand your ground might apply. Now, there may be some other defenses if you can think of, that's fine. Just make sure you support them when you do provide them. And then, of course, the quiz itself. Okay, so now let's go into my fun part, which is the lecture itself. So criminal responsibilities and defenses. We'll go until 10 o'clock tonight, and then we will adjourn at 10 or earlier, whichever comes first, completion of this. So here's this situation here, people. is quite clear that criminal responsibility, as it says, it refers to a set of doctrines under which individuals are held accountable for criminal conduct. I could use something even more simple, rules which regulate and control the actions of individuals and determine that certain actions that if you do involve yourself with them, you will be guilty of criminal conduct. And it started from common law, and common law was based on cases themselves without statutes. There were no statutes then. And it came from some fundamental things that make a whole lot of sense, such as justification, saying the action that you took was justified, or there were some excuse defenses, such mistake of fact, or self-defense, which is the big ticket that's usually involved in criminal defense cases, particularly when there are individuals that involve some kind of force. So it is very important that you understand these foundational things because in this day and time, English common law has been now put into a place with all criminal law whereby you will find there are statutes that control the conduct and determine possibly what the defenses are that you can utilize for that particular conduct. Of course, the Fifth Amendment furnishes what we call immunity defense, and what that means is you don't have to testify against yourself. You don't have to provide information against yourself. It is a constitutional right, and usually it comes out when there's an infamous phrase that you've heard before, plead the fifth. What you're really saying is that I decline to answer the question because it might tend to incriminate me. So that happens a lot. We just had a case here in Illinois where there were 15 people that were young men that were charged with a criminal act, and they were going to be retried because there were some problems in the initial case, and the conviction was subject to be overturned by a higher court. But anyway, in the retrial, the individual police officers decided that they would take the fifth, and they wouldn't provide information. But you know why? Because this was involving drugs, and as it turns out, that they were shaking down drug dealers. Therefore, any testimony they could give could end up in perjury because they would have to lie in order to protect themselves. And then lying under oath is what we call perjury, which is a crime. So they said we invoke the fifth. And if they invoked the fifth, what they were really saying is that we don't want to testify because if we testify, we will provide information that will maybe help your case, but it will also at the same time incriminate me. So that's why the Fifth Amendment is there. And then double jeopardy. Double jeopardy, it means what it says. It means you can't be tried for the same offense twice. However, there are certain exceptions, such as if you try to do an offense in a state court and then a federal court, that is not double jeopardy. Double jeopardy doesn't set in until the time when you are tried in the state court twice or in the federal court twice. So it's very, 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 very important that you understand double jeopardy. There's a really good movie, and I like to use it that provide points that I like to use for my students because they indicate how the law is applied in some real situations in some of these movies. Well, this movie called Double Jeopardy, it was, I believe Ashley Judd was in the movie and Tommy Lee Jones, and she was a person who was charged with killing her husband. And she ended up going to prison for killing her husband, and she served her time, and while she was in there, she discovered that he had faked his death. and that he had relocated to another part of the country and took her son, and then one of her friends became his new wife. Well, anyway, long story short is that she tracked him down, and when she found him, she confronted him, and he tried, of course, get rid of her. Well, the movie ends with her actually this time um, shooting him and killing him. So at the end of the movie, they come in and it states that um, you killed him, but the defense of double jeopardy operated in this instance on her behalf because she had already uh, served time or suffered jeopardy for the offense and could not be sentenced a second time for the same crime in the same instance. And so as a result, she was set free. And so that's how double jeopardy works. That's an example there. So get a chance to look at it. It's available around Double Jeopardy is the name of the movie. So there are what we call affirmative defenses and negative defenses. And they're both good defenses. It's just how they're applied. In the negative defense, you say, no, I didn't do this. In the affirmative defense, you admit that you did it, but you say you're not criminally responsible. And so you'll interject one of the defenses of self-defense or insanity or something, mistake of fact, whatever things that you discover as defenses. And some of the ones maybe stand your ground. In the instance here, it depends on if it involves force or not. So negative is saying no. Affirmative is saying yes, but that I'm not held responsible because I had a legal position that I was protecting in terms of the offense that I committed. In the negative defense, the prosecution proves sufficient evidence of the guilt of the individual. In the affirmative defense, where there was justification or excuse, such as the defendant lacked the capacity to form criminal intent, the burden shifts to the defendant to produce that information on their behalf. So it shifts. If you're going to say, I did it, but because I have a good reason, basically that's what you're saying, then you're going to have the burden of supporting that position that you take, justifying what you did, self-defense, stand your ground, and so forth and so on, some of the things that we're going to be covering in a short period of time. You were mentally incapable of committing the offense at that time. You're a minor, those kinds of things. Another negative defense is an alibi defense. And what you're doing now is you're saying you deny you commit the crime, but you're now providing, I was somewhere else. I had nothing to do with this. You got the wrong person. That's the alibi defense. At any rate, the prosecutor must prove beyond a reasonable doubt in the negative defense cases. Now, the whole case still requires, if you're going to be found guilty of an offense, that you be found guilty beyond a reasonable doubt. But in the affirmative defense, it goes what I just said. Affirmative defenses is that the defendant has to prove by a preponderance of the evidence that your defense is valid. That's the difference. So, as I said earlier, self-defense is one of the big tickets. Spent many years. It's probably one of the most valuable tools that we as defense attorneys had and used. So here we go with dealing with some of the defenses. So one of the first ones we'll deal with, I'm not going to spend a lot of time on these, is infant. You were underage. So you're not able to form intent because of your age. At common law, that was 7. But you know what, guys? The law has changed down through the years because when common law was applicable before statutes were involved, there were no juvenile courts. So with juvenile courts coming into existence, uh, it changed everything in terms of the issue of infancy. And so Kent versus United States, which involves juvenile courts. And so you need to know that in the juvenile court, we have a goal of salvaging the individual so they're adjudicated. They're not found guilty of a criminal act by the same way that you are in an adult court. But our goal is to, underlying goal is to rehabilitate those individuals and salvage them. Under certain circumstances, though, because the acts that are committed, children or minors can be tried as adults, and it depends on the seriousness of the offense. And in today's time, with the gangs and with the number of things that take place now in our area here, we have a series of carjackings that's kind of like it's an epidemic that has taken place in the last month or so in the Chicagoland area. And the thing in common with all of these carjackings are that minors are the ones, or juveniles are committing the offenses. And so what ends up happening is that these individuals are arrested, they're charged with misdemeanors, not felonies, and then they're released back and they go back. But unfortunately, what happens is that adults and the criminal business, such as drug dealers or individuals maybe have a chop shop or something, they will get these kids, give them some money, and have them to go out and commit the offenses. And when they commit the offenses, they are arrested, and they know that they're going to be released. And if they're released early, they can utilize them time and time again. So the point of the matter is that when you reach a certain level and you begin to commit offenses, you can be found guilty by being tried as an adult. However, though, the sentence that you usually get will not send you to prison where adults are. It will put you in the juvenile detention facility because we try to keep minors out of that contact with the adults. And so anyway, this talks about children being tried as adults. The youngest child sentenced to life was 13 years old, and that because of the violent offenses, there are many children tried as adults. And some of these, as given here, to justify it or explain it, the trend is that they were exposed to violence and abuse at a young age. And so I am a hard person to deal with that because I already told you my story. What I grew up in. I grew up in a home of domestic violence. I saw a lot of violent things. I was in a community where there was violence and abuse, but and I wasn't treated the best way either. But the point of the matter is that I didn't, reach out to crime. But many young people do, and you find that that's one of the causes. And sometimes defense lawyers try to use that. It's not necessarily successful as a defense, but it is oftentimes utilized to mitigate the circumstances so that the sentence that the individual ultimately receives is not a really bad sentence or a big sentence or a serious sentence. So, all right. So anyway, that's the part on that. Intoxication. I was drunk. I was under the influence of something. I couldn't be found guilty. However, though, be aware of the fact that depending on the circumstances is how you got intoxicated, whether it's voluntary. That, for example, if you nobody tricked you, it's not an excuse defense because remember what you did. You should know that you don't drive under the influence of drugs or alcohol and those kind of things. But you will probably not be successful in saying I was under influence and be found not guilty of an offense. You might be able to again use it for mitigation, but and if it turns out that you have a pattern, then we might look at you as an addict, a drug addict, or an alcoholic, and then you could be taken to some kind of program where it will help you. But in some states, used to determine whether the defendant could on specific intent. So, in other words, that goes to the mitigation of the offense. So, if you're under the influence of alcohol voluntarily, it could determine whether or not you knowingly at the time you committed the offense did so. But most courts don't say nope. General intent is what happens. What that means is very simply that no, you did it voluntarily and you should know better. And so, therefore, specific intent doesn't enter. Just merely the prosecutor just proved that you were under the influence at the time of the offense. You did it yourself without any help from anybody. Then there's involuntary intoxication. This is where the defense kicks in pretty much. Through somebody put a Mickey in your drink, or they tricked you, or something like that, or you inadvertently took medicine. I take medication every day, and I know when I take it, but I know people that sometimes will take medication and they forgot they took it and maybe take a second dose that same day. Well, that could put you in a intoxicated situation, and that's involuntarily. So in that situation, criminality is removed from the act, and but you have to be able to establish that, for example, that you were not aware. There's also situations when persons take medication, even though it'll say on there, do not drive while under the influence of this medication for so many hours, and the person took it and then they did it, but they weren't thinking at the time. In that case, you're kind of setting yourself a defense of intoxication, of involuntary. But again, the best kind is the kind that involves where you actually forgot that you had taken the medication, or that kind of thing, or sometimes that you didn't know that there was alcohol in whatever it was, or again, gets to a point someone slipped you a Mickey or put something in your drink or food or something. Insanity, let me just say this. The least used defense of us as defense lawyers, we only use insanity in situations when we exhausted any other possibility, and we had maybe a situation where a person committed the offense. This defense kind of says, yeah, that's kind of out there. For example, I'll give you one. I had a young man I represented that committed a murder of a young lady who was forgive me for wiping my eyes, but got these little things flying around here hitting the lights, and I might snap them up sometimes, little gnats. But anyway, the point of the matter is that this young man committed this offense, raped a girl when she came to his house as a meter maid, and then he killed her, stabbed her multiple times, tied her up, put her in a garbage can, rolled the garbage can away, hid the knife up under his bed. Her bloody underwear and all that were found up under the bed. Anyway, the long story short of that is that this was a heinous act, and it was crazy what he did, because the garbage can that he used had serial number, even though he rolled it away to a block away, it still traced back to his house. So anyway, I went through all the defenses, and then I had to file a motion to have him examined by a psychiatrist. And the psychiatrist came back saying, no, at the time he committed the offense, he knew what he was doing. He was well aware. So he was deemed to be insane at the time of the offense, and that's the criteria there. So the point of the matter is that the mental illness has to take place and negate the capacity of an individual to function as they normally would as a responsible person. So they have several tests. The Norton test, which says at the time of the act, the defendant was suffering from such a defect or reason that they did not know what they were doing. And so irresistible impulse, in other words, they didn't have control at the time they committed the offense. And that's one of the tests. And then there's the Durham test, which says they suffered from a mental disease or defect and didn't receive support during their lifetime. And so as a result, this is what had them operating as they did, and therefore they should not be held responsible for their actions. So with both of those, and then coming to the next page, we have the ALI standard, or the substantial capacity. In other words, they substantially lack the capacity or ability to commit the offense because of the circumstances that they had. Well, all three of these tests have kind of like become watered down and reached the point where in 1984, the Insanity Defense Reform Act said that you could produce psychiatric evidence of impaired volitional control, but they decided that impaired volitional control became inadmissible, and so that's why I was saying that it made it almost virtually impossible. But it said that psychiatric evidence could be introduced to negate the specific intent of the offense. So the bottom line was that you found individuals being found insane on a lower level. In other words, 99.9% of the time that you proposed an insanity defense, you didn't meet success with that. There was a clear and convincing evidence standard, which the defendant must prove that happened at the time. And then, of course, some states have abolished the insanity defense. In our jurisdiction, I can tell you, we always use the term, at least I did, called the, I can't think of the lady's name, Amanda Phillips, I think that was her name. Anyway, her name was Amanda, first name. This was a woman who had a child that the Department of Children and Family Services, which is the protective services agency in the state of Illinois, took custody of the child. However, they returned the child to her for whatever reason. And with the short period of time that she got the child back, she hung the child, and the child was killed. She was arrested, and then she was held in jail pending trial. And you could see this woman. She would sit in the corner, and she was just all rocking. She was balled up. She had a glazed look in her eyes. She looked like she was in a whole another sphere when you saw her, and so you could see there was something wrong. Amanda Wallace, that was her name. And so anyway, this young lady, it was determined that at the time that she hung this kid, she thought she was hanging a pig, and it was proved successful. I've seen cases where individuals have stabbed and killed their kids or someone, and they were under the impression that they were slaughtering an animal or something like that, and those are proven. But it's a very, 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 very difficult burden to overcome in terms of a defense. So a lot of lawyers, we still go through it because it is our requirement to provide a defense for our clients. However, we're not really successful, but we still do it anyway. Clark versus Arizona is one of the cases, 2006, where this guy was charged with killing a police officer. So he said that at the time that he did the killing, he was suffering from paranoid schizophrenia. And so Arizona did not include part of the Norton rule, which stated that the defendant did not understand the nature and quality of the act, and he was convicted of first-degree murder. Well, he appealed, and the U.S. Supreme Court ruled that the Arizona statute did violate his due process rights, and that states may refuse to allow psychiatric testimony short of insanity to negate mens rea requirements. So anyway, the point of the matter is that he did not understand the nature and quality of the act, and so if that's proven by evidence, clear and convincing evidence, then his defense should have been allowed. But notice what the Supreme Court did. The Supreme Court said that his due process rights, because he wasn't in the ability to be able to provide a defense, and the Supreme Court said that states can refuse to allow psychiatric testimony short of insanity to negate mens rea. So it has to be insanity. Basically, the point of the matter is that this guy was insane and suffering from paranoid schizophrenia, and there had to be some evidence that was produced to support that defense. So he was successful in applying the Norton rule because he was operating under the influence. So excuse defenses. I did this because I was under duress. Now listen to me, people. It says that the use of illegal confinement or threats of harm or coerce someone to do something he or she would not otherwise do. It has to be what we use the term gun at head duress. And, you can see me put my fingers in my head. It's like I had a gun in my head. Like, you better do this or else I'm going to blow your brains out, or either have a gun on you and I'm going to force you to do this. Then that's what we call duress. Sometimes the mere statement alone without any evidence to support that is that if you don't do this, I'm going to knock you out, or that kind of thing, may not necessarily satisfy the duress excuse. And so it's very specific, and it makes a whole lot of sense. There's a lot of common sense that goes in with these defenses. Necessity, where you're placed in a situation where it's beyond your control, and you committed a crime because you didn't really have control of the circumstances and situations at that time. Now, sometimes people will say, well, I committed this crime, this theft, because of the fact that I was hungry and I needed some food, or either I broke into this place because I needed a place to sleep. Well, it says clearly that economic duress is not accepted as necessity because of the fact that we don't want to allow people to use that as an out. So it has to truly be something that is beyond that individual's control. Again, we get back to the high 90 percentile for individuals who are unsuccessful at using this defense. Consent. Physical injury consented to must result from conduct that is not intended to cause serious injury, almost like accidental and those kind of things. It's hard. A person said, yeah, you can beat me up. That's not consent. That's not, you're not going to be able to use that as a defense to say that I beat the person because they asked me to beat them up, or they allowed me. Now, when we get into a situation that they did something that allowed me to beat them up, such as a self-defense situation, or either a stand your ground situation where you satisfied all the other requirements, and then you use force commensurate with the force that was coming at you, such as knocking a person down when they came at you, but not shooting a person just because they came at you, unless that individual was way bigger, or they may have been a martial arts person, or one of those situations, and you were smaller. Then you might have a situation of self-defense. That doesn't apply to consent, but I'm just simply trying to say that it is a very rare defense. Mistake of law. Well, that second adage tells it like it is. Ignorance of the law is no excuse. I'm sure you heard that before. Every person I know practically has heard that phrase. Ignorance of the law is no excuse. That particularly applies in strict liability offenses, where if you commit the offense, like, for example, the exercise that we had, I think, a few weeks ago in the discussions, I think we had it, or we're going to have it. I taught this class so many times, I forget sometimes which week it's in, but the point of the matter is that if your license are suspended, and yeah, I think we had that already, and that you ended up getting stopped, then the question is, should you be held responsible under the law? The answer is yes, because of strict liability. There's no mens rea requirement. There's no mental intent involved. It's just you didn't satisfy the requirements of the law. You were driving without a valid driver's license, period. Mistake of fact, innocent misunderstanding of fact rather than from criminal purpose, such as, for example, you picked up the wrong bag, the wrong coat, or something like that. It was an error. It was a mistake there. Okay. Lambert versus California, in which conviction based on the notion that defendants must be notified of their acts. Lambert was convicted of failing to register with the city as a convicted felon. There was no prior notice given. He appealed his conviction, saying that due process had been denied. The court says yes. So here's the deal here. This individual was required to register, but he wasn't given the information to let him know. This is not a strict liability type situation. This is different from a strict liability, because here is that the condition that he needed to satisfy in order not to break the law was not provided to him or made available to him. It's not something that they would consider as common knowledge, because no. If you knew and you were told you have to register and so forth and so on, and you didn't, then you were arrested, and you violated the law. So Lambert versus California stood for the proposition that in certain situations where you're required to do something, if you don't know. Now, again, that has nothing to do with suspended licenses or things of that nature. Okay. So use of force and self-defense. This is probably one of the biggest areas that I did a lot of my defense where it involved acts such as I had an individual who shot and killed 2 people in self-defense. Let me give you the scenario, and then it'll make sense. Sorry about that. I don't know what's happened. I think these things are coming in through an open window here. But anyway, this young man was conducting a crap game, and he opened the door to let these 2 guys in. And when he let them in, he went to lock the door. And when he locked the door, they got up to the top of the stairs. They went up about 5 stairs to another level, which is where the actual crap game was taking place. And when they got up there, they announced that it was a holdup. And so they pulled guns out. Well, my client had a gun in his belt. So he got his gun out, and he took his gun out, and he fired shots, kneeling and shooting at an angle, and shot them both. And they both hit the ground. And when he hit the ground, he went up the stairs, and then he emptied his gun by shooting each of them in the back several times. Well, anyway, he took off, and he ended up going to another jurisdiction, and they brought him back through extradition. And I began to prepare a defense. It took me a year, try to figure out what I could do in a situation like that. And it was a real problem because of the fact that people I had interviewed who were there said, yeah, man, they shot him. He shot them in the back. Well, we already know that shooting somebody in the back is not consistent with self-defense. So there was a problem. So I went through my investigation, and so then I got the medical report, medical examiner's report, as the cause of death of these two guys. And I saw something that was really just like a light bulb that came on. It was like the parting of the Red Sea. And what I discovered in that report was that when he shot them and they were facing him, or at least they were at a point where they were angled at the side, that he fired the shots at them and they hit the ground and they were dead. They died as a result of that single shot that was fired, consistent with him squatting down and shooting up. Well, when he came up and shot them in the back, they were already dead. So therefore, it was consistent with what I had determined at that time was self-defense to present that evidence. And that evidence, when the jury heard that, it kind of like brought them around and the whole courtroom around to because I wouldn't reveal to anybody what I was going to do. Even my client didn't really know exactly what I was going to do because he was incarcerated and I didn't want him to talk to anybody about it. And so he was found not guilty because they were already dead when they hit the ground. And so look at the elements here of the use of force. So necessary and reasonable use of force. Was it reasonable for him to use a gun to shoot these guys? Yeah, because they produced their weapons first. So he got his bullet off first and killed them. Was it necessary to use deadly versus non-deadly force? Well, the key thing is that he had the right to defend himself and the others that were there. And the force that would result in death was commensurate with the circumstance of the situation. It wasn't as if they said it's a holdup and didn't produce anything at all. Just talking in itself might not be adequate enough to produce a self-defense. Of course, though, it depends. It depends on the totality of the circumstances as to whether or not that would be successful. So then we start talking about using self-defense as an affirmative defense. Remember what I talked about earlier, the difference in affirmative defense and a negative defense is the laws that were created on the book, such as stand your ground laws. And you discover in stand your ground laws, and this was introduced to most of us, or many of us, because of what happened in the Trayvon Martin case and in Florida. And so what it said is that you have a right to protect yourself in a situation where you're not the aggressor and you're at a place that you have a right to be. And so it's another form of self-defense. In the old law, self-defense, we used to have this thing that said you had to prove that there was no way of escape for you, and then you had no way to retreat. Well, that's gone now, and it made a whole lot of sense to do away with that because it put a person in jeopardy, and they had to be thinking of a way to escape. If someone's holding a gun on you, you're not required before you can get a gun on them or get a gun from them that you have to run or try to make a way of escape. No, you have to think quickly and use force at that time to protect yourself. So that's what happens with the self-defense is that you don't have to do that. Objective tests rather than subjective tests. I mean, looking at all the circumstances and situations, it's easy to determine that you were placed in a situation. There have been instances where with people with the carry conceal laws now have had weapons and they shot a person who was a criminal. Well, that person was justified in using that particular weapon. I know of a case that I think I saw it on the news that an individual was in a store and some guys came in to rob the store and they had a gun under the carry conceal. Or they were a off-duty police officer, but I think it was a situation where the person was not an off-duty police officer, but they had a correct legal they had the legal ability to possess that weapon. At any rate, they got the upper hand on the persons who announced the robbery, pulled the weapon, and they shot and killed. And so, as a result, they could raise the affirmative defense of self-defense. Battered women and child syndrome. These are defenses that people try to use. I can tell you in domestic cases, usually, let's say, for example, here's the deal. I'm familiar with at least one or two cases, one of which I represented a person, the other one I did not, where a person was a victim of domestic violence constantly at the hands of her husband. And finally, enough was enough. And one case, which is the one that I had, the person was able to finally get to a point where they had a weapon, and the person beat them. And then while they were being beat, or shortly after they were beat, that person shot and killed them. Well, then there was another case of a young lady I know who was a friend. I didn't represent her. I probably could have gotten a jury trial and got her off using this for jurors, not judges, but for jurors, where she was constantly beat by this man. But what she did was she waited for him to go to sleep, and then she went and got a gun and shot and killed him while he was sleeping. The defense wasn't successful. However, the defense attorney, as I read the transcript, didn't dig in good enough to the jurors to paint a picture of the amount of abuse that this woman had suffered. And so therefore it was a syndrome that led her to it. And so that's one of the possible self-defenses. Child syndrome is that you have been exposed as a child to violence. Like, for example, me coming up, what I was exposed to, if I became a violent person, then I might use as a defense that this is what I grew up with. Some people try to use things, and it kind of mentions it at the end here, the movies that they watch, the TV shows that they watch, those kind of things, and the music that they listen to promote violence, and use that as a defense. Usually not very successful. So in the use of self-defense is based on defense of yourself or others. It can also be defense of property under certain circumstances as well. And then I was talking about a few minutes ago, the stand your ground law. I'm not going to elaborate on that because almost everybody in the country knows about this, okay? Because Zimmerman claimed that Martin had charged him and threatened his life, so he acted in self-defense. That's what he said. So, okay. All right. Then some other defenses are immunity. We talked about already, and again, it starts out with the Fifth Amendment right to testify against yourself or self-incrimination. Immunity can be transferred to a witness as well, where the individual is not going to be held responsible for the statements that they make under the constitutional immunity. And so that happens when, for example, a person pleads the Fifth in a court case. Other forms of immunity are where, you contractually agree that a person is placed in protective custody and provide testimony against someone, and that if there is some criminal activity that they're involved in, that they're not held responsible under an agreement of diplomatic, or rather contractual immunity. Commonly used in criminal cases by prosecutors who want to get the big fish. For example, they'll take a drug dealer who's a street dealer in order to get them to flip or turn state's evidence to testify against the big fish or the person. Pretty dangerous practice, though. That's why they have to put you in what they call witness protection to keep you from being killed. Commonly used in cases where the mafia is involved, where a person testifies against another person in which a crime which they were involved with, and the government is interested in getting that other person. However, that person is put in protective custody, and because if they are not, then they will be destroyed or killed before trial takes place, and then there is no case. Diplomatic immunity, where it involves a person from another country coming here. We'll talk about that in a second. And legislative immunity. You are the President of the United States, and you're not held to any criminal acts that you commit, except high treason or except impeachment. Then you're removed there from that. Same thing with Congress and other legislators. Now, let's look at diplomatic immunity. Here's an example here where an individual from a foreign country was here in the United States. In 2011, a U.S. diplomat killed 2 Pakistanis. The person has admitted to shooting 2 men after they pulled alongside him on a motorbike. American officials said he saw they had a gun and believed he was about to be robbed. So the Pakistan government charged this person with double murder and ignored his diplomatic status. And so the thing is that his diplomatic status would excuse him automatically from the offense there, and that's what it's saying here. Okay. Double jeopardy, I talked about this already, and so I'm not going to spend a lot of time. Can't be retried for the same thing twice. The 14th Amendment applies the double jeopardy to the states. Does not exclude prosecution in a state and federal court. I said that earlier. Mistrial versus acquittal. So in a mistrial, then that's a difference, because then if there's something that happens in a trial that creates what we call a mistrial, then trying you again does not create double jeopardy. But if you are acquitted and then they try to prosecute you again in the same level of court, i.e. state court, then in that situation, then double jeopardy kicks in. However, if you're tried in a federal court for the same offense, then that's different. This has been used a number of times in excessive force cases in the criminal courts where law enforcement is involved. But back in the 60s and the 50s, it was used to prosecute individuals who were committing murders of civil rights workers, and then they were tried by what we call the kangaroo court in their own community, friends who were actually former either participants or Klan members or whatever, and then later on the federal government would come in and try those individuals in federal court, and then they would be found guilty. The Blockberger test, I'm not going to really talk about that because basically it gets back to what I said. Here's the thing that you need to be remembered. You can't be retried for the same crime twice. That's really all you need to really be familiar with. Same evidence test, same elements rule, and that's pretty much what applies there. Statute of limitations mean what it says. It means there's certain crimes, for example, that means if the individual is not charged with that crime, not found guilty, but charged on that crime within a certain period of time, then they could not do so. Many states, though, have begun changing that, particularly in rape cases, because of all the circumstances. You recall now that there's a lot of instances of sexual harassment. In the last, I say, week or two, man, there's been a bombardment of those kinds of allegations that have resulted, some of them heading toward criminal court, such as Kevin Spacek's case is heading. We don't know what's going to happen with Charlie Rose. Those of you who don't know who Charlie Rose is, he was a noted reporter on CBS and PBS, Public Broadcasting, the Charlie Rose Show. Just today, it was announced that he was terminated by those people, but there were possible criminal actions that could take place. We had a former Speaker of the House, Dennis Hastert, who in Illinois here was a phys ed teacher many years when he was much younger, and individuals have started to bring out some of the things that he did to them. But here's what happened is that because these sentences were so long, well, what really created the problem was that the perjury of Dennis Hastert opened it so that that person could be found guilty of perjury for not telling the truth about it happened, even if it was beyond the statute of limitations. So anyway, there is rarely a statute of limitations for murder. I don't know of any jurisdictions that have it. I know ours don't. And murder can be proved many years later, as you've been able to discover, from individuals who were charged with murder many, many years and would spend time. So federal statutes are 5 years for non-capital crimes. Every state has different limitations, and then I already talked about the limitations for rape. Defendants can waive the right to the statute of limitations if they need to gain more time to prepare a defense or for plea bargaining. Then they stop the clock from that particular time. It's like, for example, we use the term the statute of limitation holds. And what it means is like a clock that's ticking, and all of a sudden we put the pause button on, and the pause button stays on while we're doing what we do, and then we get past that point, and then the time begins to run once again. Governmental misconduct. This is when we get into things like entrapment. Entrapment is when you mind your own business and the police or law enforcement officials approach you. For example, I'm walking down the street and minding my own business, and a person who really is an undercover cop, they have a setup in the area because there's been a lot of drug dealings, and walks up to me and says, "Hey, how would you like to buy some drugs from me?" And if I buy the drugs, and then pretty much they will do that with a person that they might have an idea that's a junkie, or a person that might buy the drugs. But at any rate, if that person does attempt to buy it, and then they arrest him, then entrapment kicks in because you were minding your own. And so I'm going to elaborate on that more in the next slide. But it didn't exist at common law, and it's not in the Constitution, but it is a test that's based upon all the circumstances of the situation. There's the subjective test of entrapment. The problem is that it does not establish rules for enforcement for police. But so it depends on a case-by-case basis as to whether or not entrapment is involved. And then objective test of entrapment, the court establishes that the police did something improper, like the example or scenario that I gave you just a minute ago in that situation. So I've had people say, "Oh, I was entrapped." Well, you were trying to buy drugs from a person, and you knew that person, you were buying the drugs, but you didn't know that person was an undercover cop. But you were looking for it, and you bought it or set up a deal with them. And they didn't have to reveal to you that they were a cop until you did, and then they can arrest you. That is not entrapment. The idea is that you had already formulated the intention of committing the offense, but it turns out that you were dealing with undercover cop. Then that's unfortunate for you. Here's a case here I was talking about. U.S. Supreme Court reversed this conviction of this person for soliciting sexually explicit materials, saying that the government implanted it. They knew he had a mind, but that at the time he was innocent. And so what happened was Jacobson was convicted of as a sex offender. He was one, and he was targeted by the police. In other words, okay, we're going to get this dude. So they sent mailings of sexually explicit material over a period of 26 months. And so the mailings also included communication, the communications decrying censorship and questioning the constitutionality of the government's efforts to restrict sexually explicit material. That was the whole argument. But here's the point, is that the government can't just, they knew, it's like, okay, telling a kid you can't, you can't have candy, and then putting the candy out and leaving it out for them to get it, and you're not around, so you know what's going to happen. Yeah, that kid's going to go for that candy, but you knew that. In other words, you were setting them up for that. That's kind of like what this is. Okay, they knew he was a sex offender, so they were sending him sexually explicit material, enticing him. Selective prosecution is when a person is tried on the basis of the fact that they have a certain race or ethnicity or religious belief, and the law says that's a violation of the Constitution Equal Protection Clause, Due Process Clause, and so forth, but more the Equal Protection Clause. Defendant must prove, though, that other similarly situated persons have not been prosecuted for the similar conduct. Pretty hard defense, because if you find one that fits the same as yours, even if there were others who were let go, and you find somebody else, the prosecution is able to produce an instance from either one that they prosecuted the person that fit the same mode as you, then your defense is out of the water. So not hardly used, not often used. The United States Supreme Court held that passive enforcement of prosecuting only those non-registrants who reported themselves or were reported by others was not a violation of First or Fifth Amendment. Let me explain that. This person, Wright, didn't register under the Selective Service Act, and he was convicted for failing to register. So he tried to say that, wait a minute, there's other people who have not registered. So he tried to use that as a defense. They said, nope, you're not, you're the one. Let me give you an example. When I was a prosecutor in a town, and I prosecuted for traffic violations, I remember individuals would come into court and they would say things like this. They said, wait a minute, Your Honor, I wasn't the only one speeding. There were others that were speeding, and you pulled me over and gave me a ticket. Well, that was the same kind of argument this person was making. And the judge laughed and says, then you're the one who represents the group. And so the person was like basically admitting that they had committed the offense. They were trying to say, well, you didn't get everybody. Nah, it doesn't work like that. It sounds like something one of my kids would say. You let, I have Richard and Jillian. Jillian is the baby girl, and Richard is 22. You didn't get Jillian for that? No, but I'm getting you for it. So, so you might argue that it's unfair sometimes, but that's, you violated the rules, therefore you have to suffer the consequences. Or if you commit the crime, you'll have to do the time type thing. I often used to hear people also say this is also kind of hilarious, is that back to the same traffic offense type thing, is that the speed posted was maybe, let's for example, hypothetically, 25 miles an hour, and the person would come to court and they would say, Your Honor, I didn't violate the law. He says, well, what was your speed? And they said, I was doing about 29, and so the speed limit was 25. So the judge says, but you just admitted that you went over the speed limit. So the person comes up with this defense that some people think exists, but there's no such thing ever been called the 5-mile rule, which means that if you were within 5 miles of the speed limit over, that you wouldn't be held responsible. Never was, and probably never will be the law. And so what that person was really doing was incriminating himself by that statement. So just a few of the little things that I've seen happen. And so we come to the end, and these are some novel defenses, or what we call innovative defenses, that a person tries to use as defenses. Uh, Unusual religious belief and practices, such as saying, well, my religious belief is that my child does not go to the doctor or does not receive a blood transfusion. So the law says that failing to obtain medical treatment for a child is not, due to religious beliefs, is not a valid defense. However, you could do that for yourself as an adult, but not for that child. So you can't use that defense. The person's negligence. They left their laptop in the restaurant, and I saw it. And I saw them leave, and I got it. And they would have, if they hadn't have left it, I never would have got it. Well, you knew it wasn't yours, and at the time you got it, you converted it to your own use. Therefore, so what? The person accidentally left, but you still are committing a criminal act. PMS, a person can argue that they committed the offense because of those circumstances that they were suffering in their bodies. And so as a result, the same thing with PTS, post-traumatic. What they're really saying is that that's caused it. Now, listen to me. While it may not be used as a defense, it might be used as a mitigating circumstance for possible sentencing, but it doesn't excuse the act that you commit. Compulsive gambling. I have an illness. I'm a gambler. I can't help myself. Well, if I hadn't been that way, I wouldn't have done this. Not an adequate defense. It even sounds funny just hearing it, but I have seen that those argued as possible defenses. The junk food defense. I eat junk food all the time, therefore it creates a situation in my body. It makes me commit crimes. That's basically the essence. How ridiculous does that sound? Well, but believe it or not, these are really defenses that exist in court. Same thing earlier, I talked about movies and TV. Certain TV shows you watch, violent shows, and so forth. Pornographic intoxication. And then the infamous XYY chromosome abnormality. In other words, it's genetic that I'm a criminal. Look at my face. I'm smiling. You mean you were born a criminal? I know. If the sound was up, I would probably hear you guys laughing out. So no. Don't even go there. In other words, it's not going to be an adequate defense. So anyway, those are some of the defenses. Again, summarizing, the biggest defense that you will run across is self-defense. Stand your ground in terms of a person using force, or whether or not force is necessary. The key thing is you're using the amount of force commensurate with the offense that is taking place at that particular time, and that you're not overreaching. We have a case of a police officer here who shot a young kid by the name of Quan McDonald 16 times, and the video showed that the young man was actually walking in another direction and was not coming toward the person when he did it. And not only did he empty his gun, but he started to fill up again. He's charged with murder because he went beyond what was necessary for him to even, the force was excessive. And so therefore he's being tried for murder. So his defense is not going to be successful. The case is still pending right now. So anyway, that's that. So let's go back to the classroom here. So any questions? If there are some, type them in the chat box. I'll see them. Any questions? Looks like there are none. So anyway, at this time, I'm going to adjourn this session. God. I'm going to adjourn this session, and I want to take the time to wish each of you a happy Thanksgiving, and hope that you don't eat too much turkey. You will discover that I've already graded week 7 assignments for those of you who turned them in. For those of you who have not, you have zeros in there. However, you still have the opportunity to get your assignments done, because we just passed week 7, and they will be marked late unless there are some extenuating circumstances. But the point of the matter is, if we have already made some arrangements earlier where I knew something was going on with you. So week 8 assignments, I've already gone over them and told you what they were. Make sure that you utilize the rubrics. Make sure that you look at the course calendar, click on it, and then you'll see the requirements for it. Make sure that you satisfy the requirements of the module for the assignment in itself. So it's about 9:49, so I'm going to say good night to each of you, and I'll be sending out an archive. So good night, and have a happy Thanksgiving, and enjoy the rest of the week. Good night.